Class, welcome back. Sorry for the delay. Okay. We are resuming with the question of Article 329, an election petition. Okay. Now, Article 329 of the Constitution doesn't talk explicitly about can a political party make a coalition with independent party? Okay, I'll come back to these questions. Just let me begin with what I'm trying to indicate. Maybe some of these questions will be answered alongside. Article 329 of the Constitution talks about prohibition of courts. Article 329 of the Constitution talks about prohibition of courts from entering into prohibition of courts from entering into electoral matters. This is the title of the article, that it in a way explicitly and specifically prohibits the judiciary from interfering in electoral matters, right? That the judiciary will not have the ability to raise questions on electoral matters is what Article 329 states. Now, this is a big deal because you know why? There is nothing in the country of India which is made by a law or even by the Constitution that cannot be subjected to judiciary. Judiciary can ask a question about everything which is with regard to the framework of the Republic of India, right? Whether made by the Constitution or by a law or an executive action, everything. But Article 329 specifically takes away the matters of elections away from the judiciary. You see the point? And this is a very clear indication of the separation of powers between the judiciary and the legislative, right? So, for example, you have the legislative, realm of the state, which is, in a way, decided by elections. The legislative realm of the state, which is decided by elections. Okay, this is the part that we are taking a look at, the legislative realm. Now, what happens in elections is, as we have seen, you see, under Article 327, we get a very clear understanding that everything with regard to elections has to be decided by the legislatures, right? And generally the Union Parliament. So, don't you think it's a little bit interesting to see that everything that forms the composition of the Union Parliament will be decided by the Union Parliament? You see that the composition of the Parliament will be decided by the Parliament. The methods of composing the Parliament, what is right, what is wrong, etc. It's in the hand of the Parliament altogether, right? Now, the question is that whatever happens at the level or the domain of politics, sometimes politics may do things which may not be strictly right or wrong. Okay, so for example, let's say this is the domain of the judiciary. This is the domain of the judiciary, and in this domain, what you have is like an example of what is strictly right and wrong. The domain of judiciary states that there is a what you can call legally right and legally wrong. Okay, there is a kind of a rule book order which goes with the judiciary. But politics sometimes may not believe in strict right and wrong. Sometimes there may be mixed, maybe shades of grey, and there may be some things that politicians say that if you have to operate in the real world, you can only do certain things in a certain way. Okay, though the judiciary has an ability to check upon this activity of the legislature, but nonetheless, as I mentioned, that most of the time the questions with regard to elections are sent to the electoral agency of the government of India, that is the Election Commission of India, right? And therefore, the composition of parliament and the ways in which the parliament is composed, etc., has been very specifically prohibited from judicial exercising of its power, unless the parliament explicitly makes the judiciary exercise its power. So, in most matters, the judiciary has its powers directly under the Constitution of India. But in matters with regard to Article 329, judiciary cannot have any power with regard to elections unless the parliament gives it certain powers specifically. And if the parliament does not specify any powers, interestingly in pointed terms, then the powers go to the Election Commission of India. This is what I have told you as a point about the plenary powers, right? This is what we took a look at in terms of understanding what is known as plenary powers. So, if the law is silent as to who will exercise certain judicial duties upon certain matters with regard to elections, for example, if someone has won elections and the other party has said that he has won election by malpractices, where will you go and make this kind of a claim? Now, if the constitution and the parliament are silent about where, it automatically goes to the Election Commission of India. That is the plenary power provision of the Election Commission of India, right? Or the law has to very specifically provide this to the parliament or to the judiciary to do it. Okay. So, what Article 329 states is that in general terms, the judiciary will not enter into electoral matters, and if they can enter into electoral matters, I can write this down like the judiciary can interfere in electoral matters judiciary can interfere in electoral matters only if the judiciary can interfere in electoral matters only if the parliament by law allows it to do. Okay, so in this sense you can see very clearly, if I had to in a way structure this out for you, in this you can see very clearly that it is the parliament which will be in control of the judiciary. With regard to electoral matters. It will be parliament which will be in control of the judiciary with regard to electoral matters. Clear? Right. So, this is what we are taking a look at in general terms is the crux of Article 329. Generally, the parliament cannot control the judiciary and tell the judiciary where it can exercise its abilities and powers or not. But in matters of elections, it is under the control of the judiciary, right? And see, that's the whole logic and the sentiment behind it. That sometimes judges may think of politicians as just evil, wrongdoers, as people who are inherently corrupt and inherently selfish and inherently power centric, right? Now, judges are people of the ivory tower sometimes. They don't know what ground reality looks like. They may not understand the, the hustle and bustle of Indian politics. And therefore, to give the judges this kind of a authority to provide right and wrong, black and white kind of judgments upon things that they not completely understand would be a little bit of a difficulty as recognized by the Constitution itself. Therefore, the parliament has been given the power to control the activities of the judiciaries in terms of what they want to what they want the judiciary to do in terms of the electoral matters, and that's why Article 329 has specifically excluded the judiciary out. Right now, if you for example take a look at Article 329, again it talks about prohibition of courts from entering into electoral disputes, and then it talks about two specific electoral disputes. Number one is delimitation, and it very specifically says, Article 329, that any act of delimitation done, any act of delimitation including the delimitation commission will not be challenged before a court of law. You know what delimitation is, right? Recently we have seen delimitation exercise in the state of Jammu and Kashmir, and in that we kind of understand that the report of the delimitation commission was in a way criticized for many reasons, that it is doing a kind of a communal thing or whatever. So the question was whether it can be subjected to the judicial review, and it cannot, because Article 329A clearly states that delimitation reports cannot be subjected to judicial review, right? That is very specifically stated over here. Apart from that, what you see is that the what you can call the questions about the judiciary thinking in terms of delimitation, and the second is election petitions, that it is says that any dispute with regard to elections can only be any dispute with regard to elections can only be any dispute with regard to elections can only be solved, or let's say can only be raised through an election petition. So there's a kind of a category which has been created under the Constitution, a category of petitions that has been created under the Constitution known as the election petition, right? And it says that the Parliament will decide, the Parliament will decide the authority, the Parliament will decide the authority that can hear and dispose, election petitions. That can hear and dispose election petitions. You see the point here? Any dispute with regard to elections can only be raised through an election petition. The Parliament will decide the authority that can hear and dispose election petitions, right? So it is the Parliament which will decide as to what judicial or quasi-judicial or body which is given special judicial powers to listen to the what you can call the election petition. And now please keep in mind, if the Parliament doesn't specify any authority, by an automatic reaction it will go to the Election Commission of India, because Election Commission of India has plenary powers. Article 329 is here in front of you in its entire openings. Okay. Clear? I'm hoping this is coming out clear to you. Let me take you through Article 329 of the Constitution. Please take a look at this. Please take a look at Article 329 with regard to the Speaker, with regard to the powers of the Parliament in terms of election matters. If this is what I have just told you in with regard to Article 329. So you can read Article 329 section A, which is the validity of any law relating to the delimitation of constituencies or allotment of seats on such constituencies shall not be called into question into any court. And B, no election to either House of Parliament or to the House or either House of the Legislature of a state shall be called in question except by an election petition presented to such authority and in such a manner as may be provided for by or under any law made by the appropriate legislature. You see the point? And under this, the law which has been made by the Parliament is again the RPA 1951. The provisions of RPA 1951 which deal with election petitions are now ours to discuss. So we have created a groundwork for this entirely as to what is an election petition, where does it find its origin in the constitution, who does it empower to create a framework for hearing of election cases, and under that power the Parliament, which is the empowered body, what has it done, right? So that is where we take a look at RPA 1951, right? Just let me, before you take out the draft of the RPA. I have given you the number of sections that we have to take a look at in this sense, right? Okay. Here, this is the chapter 2 of the RPA 1951. Please remember that with regard to RPA, we are covering 3 things. This is the last leg of RPA. After this, RPA would be complete. Okay. With regard to RPA, we are covering 3 things. Number 1 is qualifications. Right? Then second is disqualifications. And third is now we are at election petitions. Okay. If I want to complete this diagram, you have Article 84 of the Constitution, which talks about powers of the Parliament it talks about the powers of the Parliament with regard to qualifications. Then you have Article 101, in fact not Article 101, Article 102, from where we can talk about disqualifications. And then you have Article 329, from where we can talk about election petition. You see, it's a beautiful diagram which explains to you the way that the Constitution has been structured with regard to the RPA 1951. Right? You can easily see. And here you have the provisions of RPA 1951, which can run from, let me just complete this diagram, section 3 and 4, section 7 to section 11, and here we have section 80, 80A, 98, 99, 100, 101, 116A. Take a look at this diagram. This is a beautiful structuring of how the RPA 1951 has been, created. The constitutional provisions, Article 84, Article 102 and Article 329 have given different powers to the Parliament, and under these provisions the Parliament has created the RPA 1951, where it has given qualifications under section 3 and 4, disqualifications under section 7 to 11, and the procedure for filing and hearing election petitions are given under section 80, 80A, 98, 99, 100, 101 and 116A. Right? You can get a sense of what I am trying to talk about here. Take a note of this, please. Wait for 1 minute before you take a note of this. Okay. Right. So let me take out the provisions of RPA 1951 with regard to election petitions. Now here I am opening it up. This is chapter 2 of the RPA 1951, which is presentation of election petitions to election commission. Okay. Now this part doesn't apply very clearly. Section 80 stated that election petitions, no election shall be called in question except by an election petition presented in accordance with the provisions of this part. Take a look at this. It defines what is an election petition. Election petition you have seen previously under Article 329, and then it says that Article 329 empowers the Parliament to make a law upon election petitions. Section 80 states, no election shall be called in question except by an election petition presented in accordance with the provisions of this part. This is the part that presents the questions of election petitions. Okay. Now, before the year 1966, all the election petitions were presented to the Election Commission. It was Election Commission which was the body which was supposed to hear all the election petitions. but section 80A was introduced in the RPA 1951 to give powers to the High Court to try election petitions. Okay, so you see the point here. The Parliament can make provisions for an election petition to be presented to such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. So, using the powers of Article 329 under RPA 1951, the Parliament of India has given this power to the High Court. So, wherever there is a question with regard to elections or electoral frauds or electoral corruption or manipulation or booth capturing or any of the sort related to each other, that state's High Court will have the first jurisdiction to hear that matter by this filing of an election petition as given the procedure under section 80 onwards of the RPA 1951. Okay, so take a look at this again. Article 80A. Article 80A states High Court to try election petitions. Please read this yourself. High Court to try election petitions. The court having jurisdiction to try an election petition shall be the High Court. The court having jurisdiction to try election petitions shall be the High Court. That is 80A. Then you can take a look at second. Such jurisdiction shall be exercised ordinarily. Such jurisdiction shall be exercised ordinarily by a single judge of the High Court, and the Chief Justice shall from time to time assign one or more judges for that purpose. Right? Clear? So, this is basically a kind of a description, but what you understand is that the authority which has been given a very clear pointedness in terms of trying the election petitions is supposed to be the High Court. Okay, I'll repeat it again. The authority which has been given a clear understanding of the trial of election petitions is the High Court. Right? And so, under section 80A, you have the High Court which will try the election petitions. This is made for in reference to the point over here. Okay? Now, we move to the next part over here. Article 81. Presentation of petitions. Take a look at this. Article 81. An election petition calling in question any election may be presented on one or more of the grounds specified in section 100. In fact, we can skip article section 81. I'm sorry, we don't have to read section 81. It is not in the scope of our syllabus. Just take a look at section 80, which is defining the election petition, and section 80A, which talks about section 80 which defines the election petition, and section 80A which talks about the powers which are given to the High Court with relation to election petition. Okay, right? This is 1, this is 2. Let's take a look at point number 3, section number 98. Section 98 talks about the powers which are given to the High Court in terms of disposing the election petitions. Okay. Section 98, let me elaborate section 98 for you. Under section 98, High Court has certain powers of giving decisions at the conclusion of the trial of election petition. But once the election petition has been heard by the High Court, once the election petition has been heard by the High Court has certain powers in terms of taking decisions on the election petitions. Clear? What are those powers? There are three powers which the High Court can exercise. There are three decisions that the High Court can take. First decision is the High Court can dismiss the election petition. The High Court can dismiss the election petition. Okay, the first reason is the High Court can dismiss the election petition. B, the High Court can, but what I mean to say when dismissing the election petition is that the High Court can say, what it means is that the election petition which is challenging the results of an election is of no substance. The High Court can say that. Please take a look at this. This is the first, these are three things that High Court can do with an election petition. And the first thing that the High Court can do with an election petition is that it can say that the election petition which is challenging the results of an election is of no substance. Sorry, let me write it out again. Is of no substance. The election petition which is challenging the results of an election is of no substance. That is what the High Court can say and dismiss the election petition. This is the first thing that the High Court can do. Okay. Then second thing what the High Court can do is, High Court can say that it can declare the election of a returned candidate. It can declare the election of the returned candidate to be, it can declare the election of the returned candidate to be void. Okay, so what do we understand by the term returned candidate? Returned candidate is a person who has won the elections. So if a person has won the elections and if another person has filed an election petition saying that he has won the elections by electoral malpractices or by booth capturing or by corrupt practices in elections, then the High Court can declare the elections of the returned candidate as void, cancelled. It can cancel the elections of a candidate. It can declare that your victory is cancelled, that you will not be allowed to take up the seat for which you have apparently won the elections. Okay, this is point number B. Point number C, High Court can declare the elections as void. High Court can declare the elections as void and High Court can declare the elections as void and declare another candidate as the winner of elections. Okay, this is the third step that the High Court can take under section 98. It can not only cancel the victory of a returned candidate, but also in the place of the victorious candidate who has just been cancelled, another candidate who would have won if the electoral practice, malpractice or electoral corruption had not happened, the High Court can crown the other candidate as the winner of the elections. Okay, let me specify this if you want to have a clear understanding of it. Let's say if this is one person and this is another person, and both of them are contesting for a seat of a member of parliament in the Lok Sabha. Let's say now this person, he eventually wins the election. This person goes to the High Court and says that this person has been involved in some kind of a corrupt practice. Okay, if the High Court finds that this person is involved in some kind of a corrupt practices, High Court can declare that the election to this person is incorrect, and it can declare that actually this person is the one who should have won and declare him to be the winner. This is what is the power of the High Court under section 98. You see, so what the High Court is able to do is, in a very clear sense, trying to understand this in such a manner by which the High Court allows an election petition to be entertained before itself, and then it can either dismiss the election petition, it can declare the election of a returned candidate to be void, or it can declare the elections as void and declare another candidate as the winner of the elections. You see the point? This is what we are taking a kind of a reference of. You see, just take a look at this again silently. Try to take a note of these, and then I'll take you to section 98 clearly as to what the powers of the High Court under are. Now, this is a direct question in the UPSC. You know, the question the UPSC would state something like this, that discuss the powers of the High Court with regard to election petitions. What can the High Court do if an election petition is filed before it? Right? And the answer is these 3 points. It can either dismiss it, it can declare the election as void, it can declare the election as void, and also at the same time declare another person who the High Court thinks should have won the elections if no corrupt practice had happened as the winner of the elections. A, B and C, these are extraordinary powers which are given to the High Court, and by this we are coming very close to what we were seeing yesterday in the judge of the Calcutta High Court taking the account of what happened at the electoral exercises in West Bengal, right? Just take a look at this with regard to section 98 of the RPA 1951. Please take a look at it simply. What is written on the board here? Right? You see the point? Section 98. Let us take a look at the section 98 which is given in this part, and just say pay attention to what has been discussed over here. Just take a clear understanding of section 98 in RPA 1951. That is all you have to remember in terms of understanding the powers of the High Court in terms of election commission as to what the High Court can do. Please take a look at section 98. Right? At the conclusion of the trial of an election petition, the High Court shall make an order dismissing the election petition, declaring the election all or any of the returned candidates to be void, or declaring the election of all or any of the returned candidates to be void and the petitioner or any other candidate to have been duly elected. You see the point? Right? Okay, I hope you understand the term of returned candidate. Now let's take a look at section 99. Just briefly summarizing all of this again. Section 80 talks about election petitions. Section 80A talks about the powers of the High Court. Section 98 talks about the decisions to be taken by the High Court. Now we're coming to section 99. What does section 99 say in this regard? Section 99 says this. Let's say, for example, if this is a candidate 1, this is a candidate 2. Okay, this is candidate 1, this is candidate 2. Right? Now, if both these candidates are contesting for a seat of Member of Parliament, and both of them are involved in massive electoral campaigns against each other, right? If they're doing all that propaganda and all that kind of a campaigning against each other during this time, and let's say, for example, by the end of the elections, this person has been declared to be victorious, and this person says that this person has entered into some kind of what you can call corrupt practices. Okay, corrupt practices regarding elections. Let me remind you, we have dealt with the question of corrupt practice about elections in also section 8A. Okay, so we are taking a look at corrupt practices with regard to elections. This is what we are seeing. C1 and C2 are fighting elections against each other, and the MP is involved in certain corrupt practices who has been declared. So this person has filed an election petition with the High Court saying that this person is involved in corrupt practices, right? Now we know that High Court can either dismiss the election petition, can declare the election void, or can make this person the winner. Okay, but in addition to that, under section 99, if this person over here, if he has been found of having committed certain corrupt practices, if this person is found of having committed certain corrupt practices, then he can be subjected to disqualification under section 8A also, which means that not only is he going to be asked to vacate the seat that he was not correctly involved, or he was not correctly elected, but also he would be subjected to disqualifications. Remember the disqualifications which were given under section 8A? Disqualifications given under section 8A for corrupt practices. Do you remember that? We had written it yesterday. So the High Court under section 99 not only has a power of saying that this person will have to leave his seat and this person will take his seat, but for a further period of so many years this person cannot contest elections also. That kind of a decision can also be given by the High Court. If the High Court feels that this person has been involved in some kind of corrupt practices. You see the point? And not only this person, let's say for example, if this person is supported by another person, let's say these are some other people who are working for this person, okay, and these people are also involved in corrupt practices in elections. Let's say for example they are involved in booth capturing, or they are involved in intimidating the voters. Then the High Court shall record a name of all these people, and all these people also shall be disqualified from contesting elections. So for example, let's say if I am a person, let's break this down situation a little bit. Section 99, let's say I am a person who's fighting elections against some other person. I am declared the winner of the elections. The other person goes to the High Court, files an election petition, and in the election petition, that person states that this person, in the election petition, that person states that in the election petition, sorry, that person states that I have won my elections by committing corrupt practices. So the High Court, if it finds out through inquiry that I have committed corrupt practices, it can throw me out. And also it can put a disqualification on me under section 8A for a period of 5 years from the date of the passing of the order. You see the point? This is what we are taking a look at in terms of corrupt practices. Let's say if I am a person who's fighting elections against another person and I have won the elections, and some people under me who have been promoting me or supporting me without my knowledge have entered into corrupt practices, without my knowledge have been intimidating, without my permission, they want me to win at any cost. I am telling them, don't do all of this, we'll win fair and square. But these people are still going and saying and doing things which are corrupting the electoral exercises without my information or my consent. Then I will be asked to leave the seat because the election results has been manipulated by the corrupt practice. But these people will be recorded as having committed corrupt practices and therefore disqualified under section 8A. But I will not be disqualified, because if it is proved that I was not directly involved or I had any information about the corrupt practices people who are under me are doing. You see the point? So if I am not directly involved, or if I am involved in certain kind of practices which I feel that people are doing, if I am not involved in practices which people are let's say involved in, but they are doing it on my behalf for me, but I am not involved, I can be asked to leave my seat, but I will not be disqualified under section 8. You see the point? And if I and all my minions are involved in some kind of a corrupt practice, I will be asked to leave, and all of us will be disqualified from contesting elections, right, under section 8A of the RPA 1951. So remember, under section 8A we had discussed something about section 99. I am creating a reflection back to this at this point. You see the point? So you have this kind of a structure which you can understand. Section 99. The section 99 very simply states, let's take a look at this. Take a look at this. At the time of making an order under section 98, the High Court shall also make an order where any charge is made in the petition of any corrupt practice having been committed at the election. Okay. So the High Court can record the names of all persons who have been proved at the trial to have been guilty of any corrupt practice and the nature of that practice, fixing the total amount of cost payable and specifying the persons by and to whom costs shall be payable. Let's say for example, if during the elections a person commits a corrupt practice by which a person's property is damaged, then if the High Court records the person as having committed corrupt practice, he will tell the person to compensate the other person for the damage of the property. You see the point? He will tell the High Court to compensate to the other, High Court will tell the other person to compensate for the damage of property. And in addition to that, under section 8A, this person will also be disqualified. So this is the specification of a section 99 of the RPA 1951. Okay, this is section 99 of the RPA 1951. Take a minute and please read what is given over here. Okay. Right. So what are we looking at? We are looking at section 80, section 80A, section 98 and section 99. Election petition, High Court, decisions which can be made from the High Court on elections, and the decisions that the High Court can make in terms of corrupt practices. Okay, this has to be read along with section 8A of the RPA 1951. Okay, let's take a look at some of the questions. If for a seat fight more than 2 candidates, then who will declare winner? Whoever gets India follows the first past the post system, right? You can have as many candidates as you would like to field, and all those candidates, in terms of whoever attains the majority among those candidates, is the one who wins, right? Now, you're asking that if, for example, if a person, see, the logic is this, that the High Court will declare that person to be the winner who would have won the elections minus the corrupt practices. You see, if there are 5 candidates fighting an election and one of them is declared the winner, another one can say that if this person had not broken the bridge from which a lot of people were coming to vote, and that bridge was collapsed by this person to win the elections, if this person would not have broken that bridge, then we would have won the elections, right? I would have won the elections. So High Court has to do the analysis of saying that if the corrupt practice had not happened, who would have won the elections, right? That's basically the question that the High Court can ask. In a simple analysis of that, if the High Court is able to make, he can declare another person winner, be it 4, 5, 6, 7 or 8. Why Supreme Court has no jurisdiction regarding election petition? We are going to discuss this article. Section 116A is where we'll take a look at how the Supreme Court has a jurisdiction with regard to election petition. Okay. Can High Court declare the whole election to be void and make order of ECI to conduct fresh elections? Yes. Now that's a good question. Legally speaking, High Court can declare the entire election to be void. Okay, but only within that state, because High Court can exercise technically jurisdiction. Let's say if Lok Sabha elections happen in the state of Maharashtra, then the High Court, if it is given election petitions, can decide that all the Lok Sabha elections in the state of Maharashtra are void and they would be contested again. But beyond that, the High Court will not have jurisdiction. So that cannot extend to High Court, that cannot extend to Karnataka, because that has to be done by the Karnataka High Court and the Kerala High Court, etc., etc., right? But practically speaking, the High Court can never do that. Why? Because you see, there's a point about all of this. The power of the High Court to try election petitions has been given to the High Court by the Parliament. If the Parliament, if the politicians who are sitting in the Parliament, they ever come to understand, if the politicians who are sitting in Parliament, they ever come to understand that the High Court is overstepping its boundaries, let's say for example एक छोटी सी कोई वारदात हो गई और उसके basis पे, if a small incident happens and on the basis of that a High Court is declaring, some kind of a election to be void, or declaring the candidate to have not won, etc. According to High Court, it's a big deal, but according to politics, that's something that is not that big a deal. Okay, so if High Court becomes hypersensitive about declaring elections to be void, then the Parliament can take away the powers of the High Court under RPA 1951. You see the point? That's the whole thing about what I want to take out. If the Parliament has to take the powers out of a High Court or a Supreme Court on ordinary matters, then the Parliament has to change the Constitution, which it cannot, because the amending to the Constitutions are restricted by the Keshavananda Bharati Basic Structure Doctrine. But if the Parliament wants to take out the power of the High Court under election petitions, thinking that the High Court is hypersensitive, then it can do it by an ordinary law. And the Parliament has been given that power by the Constitution, as we have read Article 329. So it can really replace High Court by, let's say, a 5-membered body created by the President. Some 5-membered body the President can create, and that is going to be the authority that will look at election commissions, election petitions, or let's say it will create an election tribunal, a separate tribunal on which elections will be held. So the High Court cannot do oversensitively this kind of a jurisdiction or adjudication of the election petitions, because if it is overstepping and if it is being oversensitive, the risk that comes along with it, that the Parliament can say that the High Court and the courts don't understand how elections work in India, and therefore they don't have the wisdom and maturity to deal with elections in a proper manner. They are elite, ivory tower figures who are looking at everything as a problem, right? And therefore this kind of a power can be taken away, right? Yeah, model code of conduct. Just give me some time. I'll come to model code of conduct. I feel take. I have taken a note of that. With regard to model code of conduct, I'll give you an entire elaboration about how things are over there, because that's also an important part of our syllabus. We'll take care of model code of conduct. Don't worry. This means High Court's decision under Article 98, 99 and also Article 8A. Also, by the way, these are not articles, these are sections. Just to clarify you, when we write the term article, we use article only with relation to the Constitution of India. Only the Constitution of India has articles. Okay? Articles are not there with the statutes made by the Parliament. Statutes made by the Parliament have sections. Statutes made by Parliament have sections. They do not have articles. Okay? High Court's decision under section 98, 99 and also section 8A can only be done through an election petition and not suo motu. Yes, that's correct. But of course, the High Court can ask any person informally to file an election petition, and then could happen. So it's just like a formality. You can ask a person to file an election petition. If you are a High Court judge and if you want to take up a matter informally, just circulate the news that you can entertain an election petition like this, and it will come to you. So there are many hacks given in this informal structure of Indian judiciary by which a matter can be taken up. Yes, but technically speaking, it cannot be done suo motu. Biswajit, how can we prove that a candidate engaged with corrupt practice if he say that he is not directly engaged but is influences on it? Why security money need to submit in president and vice president election? Okay, these are two different questions. How can we prove that a candidate engaged in corrupt practice if he say he not directly engaged? That's what an investigation is for, right? You are conducting, High Court has a judicial powers to order an investigation into a certain matter, even by the CBI in certain cases. You see, the High Court has powers to use special polices in the country or the normal polices in country to order an investigation into a particular thing, and these special polices like the CBI have to present the case before the High Court as to what their findings are, and on the basis of that the High Court can take cognizance of things and do things, right? So aisa thodi ki it's just, the High Court doesn't have any means or ends to find out what the person has done or not done. Okay, all right. So I'm hoping that this part is till now clear. Now we are moving to section 100 and section 101. Section 100 and section 101. Now this is a question about grounds for declaring election to be void. Okay, but basically if the High Court has to declare an election as void, what are the grounds? If the High Court has to declare an election as void, what are the grounds for it? What are the reasons for which the High Court can declare election to be void? Okay. Take a look at section 100. Grounds for declaring an election to be void. Subject to the provision, the High Court is of the opinion that on the date of his election, a returned candidate was not qualified or was disqualified to be chosen to fill the seat under the Constitution or this Act. He shall be considered to be covering a ground on which he can be removed. Okay. So the first ground we can write over here is not qualified or disqualified. Right. So if the High Court finds out that the person who has won the election has done some kind of a thing, but by which he has hidden the fact that he was not qualified or disqualified, not qualified under Article 84 and Section 3 and 4, and disqualified under Article 102 and 7 to 11. If this fact is hidden from the from the authorities at the time when he was filing his nomination papers, etc., then he can be removed. So this is the first ground for disqualification. What is the second ground for disqualification? That any corrupt practice has been committed by a returned candidate or his election agent or by any other person with the consent of a returned candidate or his election agent. Right. The second ground is, of course, corrupt practices. We've taken a look at what corrupt practices is in detail. If the person is involved in some kind of a corrupt practice, directly or indirectly, then this is a reason by which a person can be declared to be to have won the elections illegally, and from that sense he can be thrown out. He can be asked to leave the seat. His election can be declared as void. Not qualified or is involved in a corrupt practice. Right? यहाँ पर हम और लगा देते हैं. Okay. Take a look at third. That any nomination has been improperly rejected. Okay. So let's say, for example, if the Election Commission of India, while taking the nomination of any candidate, has rejected a candidate on grounds that he was disqualified, but he was actually not disqualified. I'll just explain to you. Please take a look at this. Improper rejection of nomination. What does it mean? That if a person has been, let's take an example over here. If this is one person, this is another person, this is another person, all of them are filing their nomination. Nomination meaning namankan. They are saying that we want to contest elections. Okay, with, let's say, for example, Election Commission of India. Now let's say this person filed his nomination is accepted, this person files his nomination is accepted, but this person's nomination is rejected by the Election Commission of India. Okay, eventually the election is contested by this person and this person. Eventually the election is contested by these two people, between these two people, and this person is not allowed to contest elections. Later on it is found out that the rejection of his nomination, later on it was found out that the rejection of his nomination was improper. मतलब किसी न किसी तरीके से this person was not allowed to contest elections. Okay, that his rejection was politically motivated, or he could have won the elections, but because he could have won the elections, he was not allowed to contest elections. For some reason, his nomination was rejected, and that rejection was improper. On the basis of this, the High Court can declare the election here as void. This is a ground which has been given over here, on the basis that a person's nomination has been improperly rejected. Okay, you see the point? By the improper acceptance of any nomination, that any nomination has been improperly rejected. Clear? Third ground. And D, that the result of the election insofar as it concerns a returned candidate has been materially affected. Okay, so let's first take a look at the first three grounds. High Court, to declare as an election as void, can have the following grounds / reasons. Number one, the person who has won was not qualified or was disqualified, but he did not declare it that way. Number two, he has been involved in corrupt practices. Number three, that any of the nominations were improperly rejected. And then we take a number 4. Number 4 is a little, in a way, elaborate. Number 4 states that if the winning, or let's say if the victory of the returned candidate is materially impacted victory of the returned candidates it is materially affected by, okay, here number 1, improper acceptance of any nomination. B, by any corrupt practice committed in the interest of the returned candidate. C, by the improper reception, refusal or rejection of any vote or the reception of any vote which is void. Or D, by any non-compliance with the provisions of the Constitution of this Act or of any of the rules or orders made under this Act. Just take a look at this. Please try to focus for 1 minute and try to read this point D, that the result of the election which has declared the returned candidate to be the winner has been materially affected. Matlab, the person who has been declared as the winner has been declared the winner because of one of these factors. If this did not happen, then the person would not have been declared as a winner. What is A? The improper acceptance of nomination. B, by any corrupt practice committed in the interest of the returned candidate. C, by the improper reception, refusal or rejection of any vote or the reception of any vote. And D, by any non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act. You see the point? Right, these are the 4 sub-points which are given under section 100 as grounds upon which a person's election can be declared to be void. Right, A, B, C, and then D has 4 parts to it. If you kind of memorize these 4 parts along with the chart that I have made over here, that would be completely sufficient for you to write an answer upon this. So, question like this will come in the UPSC main examination, that you have, for example, the grounds upon which an election can be declared to be void under RPA 1951, right? And you have four parts to it. A, B, and C have elaborated over here, and D can be, in a way, listed out in different categories 1, 2, 3, and 4. Right, so I suggest that you can read this directly from the section 100 of the RPA as it is given in the Bayer Act itself. Right, take a look at these. These are not very difficult to remember. Okay, so with this we can come to a complete understanding of section 100. Let me just pull out a UPSC paper from which you can take a look at the questions that are asked from the governance section. Please take a look at this case. This is a question. I'll leave it on the screen. See if you can read this question and answer a question like this. This is a 2022 last mains examination. This question was asked. Please take a look at this. Question number, I think this is question number 11 of the UPSC main examination. Please take a look at this. Clear? This is exactly the kind of question that you can prepare yourself for. Okay. Now I'm going to just skip section 101 for some time. I'll come to section 101 back in a little later time. I'm going to move directly to section 116A. Section 116A talks about appeals to the Supreme Court. This is the question that one of you asked, that can the Supreme Court not have a jurisdiction with regard to election petitions? Yes, it can. Supreme Court can have the jurisdiction with regard to election petitions only if there is a appeal made to the Supreme Court, not original jurisdiction. Okay, so Supreme Court cannot have original jurisdiction on election petitions. Supreme Court cannot have original jurisdiction on election petition. And number 2, Supreme Court is the final appellate authority. Supreme Court is a final appellate authority. Supreme Court is a final appellate authority where Supreme Court is a final appellate authority where an election petition can be disposed, can be decided. Let's take a look at this. This is article section 116A, appeals to the Supreme Court in terms of the election petition. Cannot have original jurisdiction of the election petition. Original jurisdiction on election petition can only be there with the High Court. Only the High Court can have an original jurisdiction of election petition. Okay. And Supreme Court is the final appellate authority where an election petition can be decided. Okay, it is a final authority where an election petition can be decided. Clear? Just let me take you to section 116A and we can wrap up the entire RP 1951 by covering section 116A. Then section 101 I'll come back to later. Take a look at this, section 116A, please. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie to the Supreme Court on any question, whether of law or fact, from every order made by a High Court under section 98 or section 99. We have read section 98 and 99. Okay. Every appeal preferred under this chapter shall be made within a period of 30 days from the date of the order of the High Court under section 98 or section 99. Every appeal made under this chapter shall be made within a period of 30 days from the date of the order of the High Court under section 98 and section 99. Provided that the Supreme Court may entertain an appeal after the expiry of the said period of 30 days if it is satisfied that the appellant had sufficient cause for not preferring the appeal within such period. Okay. This is a part that you can understand therefore. Okay, so we are done with the provisions of the RPA 1951 and the entire chapter upon elections is finally over. Okay, clear? I think we can start to just summarize this a little bit. 84, 101, 102, 103. These are articles on qualification and disqualification. 324, 325, 326, 327, 328, 329. These are articles on elections from article 329 and 324. Then you have RPA 1951. Again, let me repeat: section 3, 4, 7, 8, 8A, 9, 9A, 10, 10A, 11. This is all about the disqualification proceedings. And then you have 80, 80A, 98, 99, 100, 101 we still cover, and 116A. All the questions regarding RPA will be covered if you have a clear, categorical and simple understanding of these parts. Once these parts are covered, you will not have to have any problems with regard to whatever the questions are. First of all, with relation to elections, and within elections, RPA 1951. Nothing will be asked outside what we have discussed in the class in the examination. Okay, Preetham had said, explain section 100, subsection D. 1 second. Okay, what section, what you're talking about D here, right? Section 100 point D. This one you're talking about, Preetham, just see if I'm able to get it correctly. As a point 3 you're talking about, okay, here, right. By the improper reception, refusal or rejection of any vote, or the reception of any vote which is void. Very clear, right? What it means is that, let's say, if this person is a person who has what you can call a voter ID card, voter ID, which has one vote on it. Now, let's say, for example, by manipulation, this person ends up casting 5 votes, right? Which is 4 votes are illegal. Let's say this person has manipulated and cast 5 votes, out of which 4 votes are illegal. You see what happens? If these 4 votes are counted as illegal, now take a look at this. By the improper reception of any vote, or the reception of any vote which is void, which basically means that if the returned candidate has won because of the improper reception of any of the votes, if the returned candidate has won because of the improper reception of these 4 votes which were void, illegal, and it is found that they are void, then the candidature of the returned candidate can be cancelled. The victory of the returned candidate can be cancelled. That is what it means by improper reception. Reception matlab receiving votes which are void. Clear? ठीक. Okay, so we come back to this chart and finally conclude all of these things completely. Right. Okay, we can start taking notes upon whatever we have covered till now. Okay, you can put a heading now. I am going to give you very brief and descriptive notes about everything that we have covered till now from the start to the finish. Okay, so you can give the heading elections. Right, these are not going to be very extensive notes, but will suffice for you to write your mains answer in terms of what we have covered on these points. Okay, and within elections, write down first point, qualifications. Start writing from here. Give the title elections and write down the first point, qualifications. I just, whatever I have taught you, I'm going to structure it out in a set of written notes that you can take a look at and clearly answer the questions which come for the main examination. Okay, start writing. We'll try to cover the notes very quickly, not take too much time upon it, because most of the things that you have understood clearly, and you have your handwritten jotting downs which are going to be helpful in understanding the points easier. Okay, write down qualifications. Okay, we'll write in a point wise framework. Start writing. Point number 1, Article 84 of the Constitution. Article 84 of the Constitution. Article 84 of the Constitution lays out. Article 84 of the Constitution lays out the qualifications for becoming an MP. The qualifications for becoming an MP. Article 84 of the Constitution lays out the qualifications for becoming an MP. Lays out the qualifications for becoming an MP. Point number 2, qualifications for becoming an MP. Point number 2, the article mentions two constitutional qualifications. The article mentions two constitutional qualifications. The article mentions two constitutional qualifications. The article mentions two constitutional qualifications, which are citizenship of India, and minimum age. That is 25 for Lok Sabha and 30 for Rajya Sabha. Citizenship of India and minimum age, that is 25 for Lok Sabha and 30 for Rajya Sabha. 25 for Lok Sabha and 30 for Rajya Sabha. These are two constitutional qualifications which are given in the Constitution directly. Okay. Point number 3, write down. Article 84 empowers the Parliament. 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 Article 84 empowers the Parliament to make additional qualifications by enacting a law. empowers the Parliament to make additional qualifications by enacting a law. 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 By enacting a law, comma, under this power, Parliament has enacted the RPA 1951. Under this power, the Parliament has enacted RPA 1951. Under this power, the Parliament has enacted RPA 1951. RPA 1951, under which RPA 1951, under which Section 3 and 4 and Section 3 and 4 describe qualifications for MPs. Describe qualification for MPs. Under which Section 3 and 4 describe qualifications for MPs. Section 3 and 4 describe qualification for MPs as any person who can vote in an election to the Lok Sabha from any constituency in India. Any person who can vote in an election to Lok Sabha from any constituency in India. Any person who can vote on an election to Lok Sabha in any constituency in India. From any constituency in India. Full stop. Full stop. Next point, write down after this next point. Previously RPA 1951 provided that MPs from Rajya Sabha can only contest elections from the states where they have been enlisted as voters. From the states where they have been enlisted as voters. From the states where they have been enlisted as voters. From the states where they have been enlisted as voters. Contest elections from the states where they have been enlisted as voters. Comma. This provision was amended in 2003. This provision was amended in 2003 by the Parliament. This provision was amended in 2003 by the Parliament. This provision was amended in 2003 by the Parliament to bring qualifications for Rajya Sabha MPs. To bring qualification for Rajya Sabha MPs at the same footing as Lok Sabha MPs. At the same footing as Lok Sabha MPs. Qualifications for Rajya Sabha MPs at the same footing as Lok Sabha MPs. At the same footing as Lok Sabha MPs. Bring the qualifications for Rajya Sabha MPs at the same footing as Lok Sabha MPs. Full stop. Next point. This amendment was challenged before the Supreme Court. This amendment was challenged before the Supreme Court. This amendment was challenged before the Supreme Court, but the Supreme Court did not declare it as invalid. The Supreme Court did not declare it as invalid. The Supreme Court did not declare it as invalid. Supreme Court did not declare it as invalid. And stated that Rajya Sabha does not necessarily work. Stated that Rajya Sabha does not necessarily work in the interest of the states. Rajya Sabha does not necessarily work in the interest of the states. And therefore, the amendment cannot be seen to be as a violation of the federal structure of the Constitution. A violation of the federal structure of the Constitution cannot be seen to be as a violation of the federal structure of the Constitution. Comma. By this judgment, Rajya Sabha was no longer considered. By this judgment, Rajya Sabha was no longer considered an essential feature of Indian federalism. An essential feature of Indian federalism. By this judgment, Rajya Sabha was no longer considered as an essential feature of Indian federalism. Was no longer considered as an essential feature of Indian federalism. You see the point? Right. Take a look at this point about 86, question number 86. And this is a question which was asked in 2021 by the UPSC. You see, this is a question which was a very difficult question in the prelims paper. And this was a question which is obviously given incorrectly in most of the reference books that you read. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? Right. Now look at option number A, look at option number B. First is independence of judiciary. Second, the union legislature has elected a representative from constituent units. Right. The union legislature, which means Rajya Sabha, has elected representatives from constituent units, which means state legislative assemblies. Which means that, is it true that because the Rajya Sabha is elected by the members of the state legislative assembly, Rajya Sabha is an essential feature of federalism in India? Right? And so you see, if you are taking a look at the questions to answer this question between A and B, and if you contest A with B, you will be confused unless you are aware about this judgment of the Supreme Court, in which the Supreme Court had said that what is such a big fuss about the Rajya Sabha being the representative of the states. It doesn't do anything for the states. As I mentioned yesterday, that some of the member of parliament from Rajya Sabha will not even remember from which states they came from. You see the point? So the answer was here, point number A, independence of judiciary is ensured, and point number B over here is rendered as incorrect. Right? A lot of people had a lot of confusion. They did not attempt the question, or they attempted this point number B as the the correct answer. So these are issues which we are supposed to be a little careful about in terms of dealing with these questions. Right? Please, if you can take a look at this again, and you will be able to understand what I am trying to say over here. The union legislature has elected representatives from the constituent units is not necessarily an essential feature of the Indian federalism. Independence of judiciary is a better conditioned essential feature of the Indian federalism. Right? I hope this makes sense to you. Okay. So this is again Kuldeep Nayyar versus Union of India 2006 that I have been telling you about all this while. Right, down the next point after this. Now we are done with the qualifications part. Okay? You can give the next title over here as disqualifications. Qualifications is done. You can start writing about disqualifications. Okay, write down the first point in disqualifications. Article 101 mentions 6 grounds. Article 101 mentions 6 grounds. Under which Article 101 mentions 6 grounds under which an MP can be disqualified. Mentions 6 grounds under which an MP can be disqualified. An MP can vacate his seat. Can vacate his seat. Okay, write down. Point number 2. These grounds are point number A. These grounds are point number A. I'm sorry, I'm just missing a little bit over here. We are not talking about 6 grounds here, we're talking about 4 grounds here. My bad, sorry. 4 grounds under which he can vacate his seat. And these grounds are point number A. These grounds are point number A. Point number A, write down. Holding MP seat in Lok Sabha and Rajya Sabha simultaneously. This is a ground for vacancy. Holding MP seat in Lok Sabha and Rajya Sabha simultaneously. Holding MP seat in Lok Sabha and Rajya Sabha simultaneously. Holding MP seat in Lok Sabha and Rajya Sabha simultaneously. Holding MP seat in Lok Sabha and Rajya Sabha simultaneously. Point number A. Okay. Then point number B. Holding MP and MLA seat simultaneously. Holding MP and MLA seat simultaneously. Holding MP and MLA seat simultaneously. This is point number B. Okay. Point number C. Disqualification under Article 102. Disqualification under Article 102. Disqualification under Article 102. Disqualification under Article 102. And D. Resignation. Subject to the acceptance of the Speaker. Resignation subject to the acceptance of the Speaker. Resignation subject to the acceptance of the Speaker. resignation to the subject to the acceptance of the speaker. These are the 4 grounds upon which a seat can be rendered to be vacant. Okay, right? Then we can move on to the next part about disqualifications. I think you are getting a very clear understanding of how we are structuring all of this, etc., etc. Right? We have covered a huge chunk from the governance portion, right, which is the RPA and the whole issue around elections. And please don't forget the fact that we had presidential elections this year, and we are seeing the questions on presidential elections in the prelims examination. You cannot overestimate the range of questions which are going to be asked from the prelims examination from the Lok Sabha elections, and that's why I'm very emphatic in covering all of these details in meticulous analysis, so that you are prepared for that kind of a question answering. All right, take it. So fine, we'll break for today. Let me see if there are some questions. Due process of law and procedure established by law. Okay, I think tomorrow this will require a little bit of an explanation. Let me take up due process of law and procedure established by law tomorrow. Just remind me. Your name is not here who's asking the question, so please remind me tomorrow. I'll explain the whole case of the due process of law, and also maybe 1975 and national emergency case. And also I'll try to give you an insight, let me read tonight, about what is happening in West Bengal in terms of the Panchayat, State Election Commission violence itself. So I'll be able to give you some amount of understanding to the state specific issues in Bengal with regard to elections in Panchayat. Right. Thank you for your time and patience. I'll see you tomorrow. Thank you.